So welcome all to our first public seminar on the exposure draft of the Disability Services and Inclusion Bill 2023, which is available on DSS Engage website. Before we begin, I would like to acknowledge the traditional owners and custodians of the many lands on which we are present on today while meeting virtually, and pay my respect to their elders past and present. I would also like to extend that respect to any Aboriginal and Torres Strait Islander peoples present in this seminar today. My name is Vera Mitrovic. I'm the Director of the International Legislation and Program Support section at the Department of Social Services. Our section is tasked with working on the new Disability Services and Inclusion Bill. I'm a middle-aged woman with medium-length hair, glasses, and a striped top. I'm today joined by a few of my colleagues who are also working with me on the new bill and also making sure that all the technical stuff is working well today. Some of them are Caitlin, Afrouz, Hannah, Kate, Maddie. And I'm also joined by Auslan interpreter. I think you can all see her, Madison English. Hi, Madison. Before we start, I would just like to also remind you that we are video recording today's meeting as indicated in our invitation. This means that we will collect your name as well as anything you include in the question and answer function within this meeting. The reason we are recording is for note-taking purposes and to allow the department to refer to when collating feedback raised from the meeting. Therefore, if you do not wish your name or personal views collected as part of this recording, you have an option to engage anonymously using Mentimeter, which will be our preference for today and the details of which you will see shortly. You may, of course, choose not to say anything in today's meeting, but you have an option of raising any issues or questions with us outside of this meeting. Again, the details will be up for you shortly. In terms of how we conduct these seminars, we have muted people's microphones and turned off chat and cameras for the purposes of the seminar. If you have any questions about the bill during this session, please go to, and you can see these details, to www.menti.com. That is www.menti.com. And once you go to the website, you will need to enter the code 86848027. I'll just wait a little so you can note that down if you wish. We will remind you of these details again at the end of the seminar when we are going to answer your questions, as well as the questions we received before the seminar. So I just mentioned actually that there are other ways for you to contact us. One kind of the detail is provided on DSS Engage, where all the consultation material is available. So, just starting with a bit of a background, a lot of you are familiar with this. The Australian government is preparing to replace the Disability Services Act 1986, the current act. The Department of Social Services, our department, Department VAIN held a public consultation from 7th of November last year to 12th of February this year. That first consultation was to explain the government's intention to replace the current act and to give people the chance to provide feedback about the new act. Feedback from that round one consultation was considered and used to draft the Disability Services and Inclusion Bill, which you may have had a chance to look at and is available on DSS Engage. So the bill is draft legislation aiming to replace the current act. The department is now conducting a second round of consultation specifically on the exposure draft of the new bill. Our main goal for this presentation is to provide you with an overview of the bill and how each of its elements is intended to function. Hopefully that will make it easier for you to provide any feedback you might have. So the next slide describes the scope of the bill, meaning what the bill does and does not do. The bill aims to promote national consistency around the supports and services provided by the Australian government for people with disability, their families and carers outside of the NDIS. It provides authority for the Australian government to fund services and supports, and this enables continued funding of things like advocacy or disability employment services, for example, and it allows for a broader range of supports to be delivered. But it does not change or reform or create new programs. These are separate decisions for the government. The bill also reinforces a person-centered approach and establishes quality and safeguarding arrangements to help keep people with disability safe while receiving support and services. So on the next slide is how the bill will work with other legislation. So this bill, of course, exists alongside other Australian legislation, as well as international obligations like the United Nations Convention on the Rights of Persons with Disabilities. And it is intended to ensure that this bill will work in conjunction with these and give effect to them. This bill complements other national legislation, significant ones being Disability Discrimination Act 1992, Social Security Act 1991, and NDIS Act, and others, of course. So the bill works alongside these acts and takes into account them and other relevant legislation when used to design new supports and services. And I would like to note here that this is a step forward in comparison with the existing bill, because it specifically describes the considerations which need to be made when designing new supports and services. The bill is intended to be flexible to enable the government to respond to changing needs and circumstances over time. I will now move on to describe, to give you an overview of the bill. So the bill includes 5 parts. Part 1 is preliminary. It covers the introductory aspects and definitions to set up an overall framework and goals of the legislation. Part 2 addresses funding arrangements It includes funding options, the types of supports and services that can be funded under the bill, as well as various conditions for receiving the funding. I will talk about each of these parts in a bit more detail in a minute. Part 3 is relates to code of conduct and certificates of compliance. This part of the bill outlines quality and safeguarding arrangements, as I mentioned before, to keep people with disabilities safe when receiving supports and services under the bill. Part 4 addresses information management, so arrangements to keep information safe. And part 5 is miscellaneous, meaning it deals with administration and other matters, including the power to make rules, delegation of powers by the minister and the secretary of the department, and the application of the bill to partnerships and unincorporated associations and trusts. So the next slide will cover part 1, objects and principles of the bill. These are listed at the beginning of the bill. The objects describe the general aims of the legislation, while principles provide guidance for actions taken under the bill. Objects and principles have been drafted very much based on feedback from the first consultation, which included, so we'll just mention some, using modern language in the bill, which considers human rights and person-centered approaches to support and services, shifting the aims of supports and services to focus on capacity, experience, empowerment, potentials and goals for people with disability. It also included mentioning Australia's obligations under international law, including the Convention, and making objects and principles consistent with other laws like the NDIS Act and the Disability Services Principles and Objectives Instrument. The objects and principles, we're just going to move on to the next slides, which still covers objects and principles. They make clear that people with disability will be at the center of the Act, and again highlighting that they work in conjunction with other laws and within the scope of the bill. So the objects of the bill make it an aim of the legislation in conjunction with other laws to give effect to Australia's international obligations. When designing supports and services, the Commonwealth must think about how we follow international human rights treaties and conventions. And while contractual arrangements generally cover the obligation of service providers to be mindful and aligned with all relevant legislation, including it in the bill just makes it more transparent and is a further step to ensuring that this is in place. The objects also describe what should be considered when designing and delivering supports for services and services for people with disability. When it comes to principles, they make sure that the legislation is framed in terms of the rights of people with disability. These principles frame the expectation that people with disability, of course, have the same rights as other members of society, regardless of origin, nature, type, and degree of disability. Some of these rights include living a life free from violence, neglect, abuse, and exploitation, realizing individual capacities, exercising choice and control in decisions that affect people with disability, and so on. On to the next slide and moving on to definitions. So the first consultation asked whether term disability should be defined in the bill. We received a mixed feedback on this question. We received a number of definitions, suggested definitions, as well as had people opposed or strongly opposed to any definition. With this in mind, this bill does not define disability or limit supports and services to a specific target group. Categories of supports and services are defined in broad and general terms. The intention is to ensure that the bill is able to support a wide range of services and will continue to be fit for purpose in future. Target groups, I just need to note, can still be used at the program level and often are, in order to ensure that supports and services are tailored to specific needs. And also noting it is still going to be a matter for governments to decide what sorts of programs and measures to design. Our main purpose here is to ensure that the bill does not limit government's ability to design these measures. So I'll just move now to describe for you, or rather list for you, the types of supports and services on the next slide. So the supports and service categories in the bill include accessibility, accommodation, advocacy, capacity building, education, employment, independent living, information, recreation, research and evaluation, respite care. So this list of categories is broader than what is included in the current Act, and the intention is that they provide broad authority to allow a range of programs and activities to be funded. While the type of programs funded, including funding levels, they remain decisions for the government, as I said, and are not directly defined by this bill. In part 1 of the draft bill, there are definitions of these categories. And we made sure that they are quite broad, so that the types of supports and services the government can fund can be flexibly designed to respond to the needs and changing circumstances for people with disability, including their families and carers. Let's move now to part 2 of the Act and on to arrangements and grants. The current Act only allows for funding through grant arrangements, and the new bill broadens the funding options to include other financial arrangements such as procurement or contract. A more inclusive list of service categories and funding options will mean greater flexibility to create future supports and services that are responsive to emerging needs and new circumstances. When it comes to statutory funding conditions under Part 2, the bill contains these conditions, meaning that the person receiving a grant of financial assistance or to whom money may be payable under an arrangement must comply with statutory funding conditions and any other terms and conditions set out in a funding agreement. A breach of these funding conditions can result in termination or variation of the funding agreement and publication of information about the breach. These conditions include complying with the code of conduct. So this is a new element, and we'll talk a little bit more about it. It includes holding a certificate of compliance or being covered by a determination if the arrangement of grant is a regulated activity. It includes implementing and maintaining a complaints management and resolution system appropriate to size and operations of a specific service provider, as well as implementing and maintaining an incident management system, again appropriate to the size and operations of a particular provider. And it also includes a requirement to not being subject to an NDIS banning order. So if a provider is banned from providing services under the NDIS, they will not be able to provide services under this Act. Once this bill becomes an Act under this bill at this stage. Moving on to part, again, still under part 2, statutory funding conditions. Just a little bit more on this. By placing these conditions in the bill rather than in contracts or grants agreements, I mentioned this shortly, expectations and requirements for providers are made clear and transparent. This is intended to also make clear what people with disabilities should expect, and therefore making it easier to identify when providers are failing to meet these requirements. Requirements for complaints and incident reporting are broadly consistent with the NDIS. Including the requirement, including a position to exclude banned NDS providers from providing non-NDS disability services. Now moving on to the code of conduct, the next slide. As I said, the bill introduces the power to implement a mandatory code of conduct for all service providers, key personnel and workers. The aim is to ensure, again, that people with disability can expect the same standards of behavior, regardless of the source of funding for providers. The Code of Conduct will apply to all service providers funded through this Act. Similar to the NDIS, it will not have attached auditing requirements. However, failing to uphold the Code of Conduct is a breach of a statutory funding condition. So, depending on the severity of the breach, funding arrangements can be varied or terminated. If, for example, a person with disability lodged a complaint about a service provider, and during the usual course of follow-up, the department identified a breach of the Code of Conduct, further action may be taken. So just getting to actually remind you of the Code of Conduct. This slide actually spells it out for you. It is intended for the Code of Conduct to be modeled on the existing NDIS Code of Conduct, which requires workers and providers to act with respect for individual rights to freedom of expression, self-determination, and decision-making in accordance with relevant laws and conventions, to respect the privacy of people with disability, to provide supports and services in a safe and competent manner with care and skill, to act with integrity, honesty and transparency, to promptly take steps to raise and act on concerns about matters that might have an impact on the quality and safety of supports provided to people with disability, to take all reasonable steps to prevent and respond to all forms of violence, exploitation, neglect, and abuse of people with disability, and to take all reasonable steps to prevent and respond to sexual misconduct. Moving on to the certification. In the current Act, there is a provision for certain providers to be audited against the national standards for disability services. This requirement will be maintained. The bill, however, provides greater flexibility by providing power for the Secretary to determine that a certificate of compliance is required or not to deliver a particular supportive service. This decision will be based on the level of risk involved in service delivery, and it also ensures further programs can be subject to appropriate regulatory oversight without requiring amendments to the legislation. Now moving on to part 3, which is about, or we'll talk about recognition of other standards. We know that a number of providers currently undergo certification against multiple standards, potentially including national standards for disability services, NDIS practice standards, aged care quality standards, and other standards indeed. The feedback from the first consultation also indicated a broad preference for regulatory alignment, both in the interest of of establishing consistent quality standards and to address providers who may currently be required to undergo similar multiple lots of audits. The bill therefore includes a power for the Secretary to recognize compliance with an alternate standards to fulfill the certification requirements of the bill. For example, the Secretary could determine that for a particular activity, certification against the NDIS practice standards fulfills the requirement. The intent of this part is to reduce regulatory duplication, but to continue to ensure the quality and safety of funded activities. Now, next slide, we'll just provide summary. So again, the bill provides authority for a range of supports and services for all people with disability, including those not eligible for the NDIS and relating to supports and services outside of the NDIS. Supports and services will need to be person-centered and focus on capacity, experience, empowerment, potential and goals. As a reminder, the objects and principles in the bill are outlined in part 1 of the bill. Broader service categories and funding options will provide flexibility to respond to needs and changing circumstances. And supports and services will continue to be subject to quality and safeguard checks to make sure that they are appropriately delivered. Now to the next slide, again, how to provide feedback. On the DSS Engage website, you can complete a guided questionnaire. You can upload a submission, or you can do both. The DSS Engage includes a range of materials to facilitate your feedback. For example, it hosts exposure draft of the bill, explanatory memorandum of the bill, plain English summary of the bill, and summaries of the bill, including tailored documents for service providers and people with disability in easy read and Auslan. We have already received a number of responses to questions in the guided questionnaire and look forward to hearing more feedback. The public consultation will run until 13th of August. After this consultation, the government will consider all feedback received and decide on next steps. Now, just on the next slides, again, providing details for you on how to provide questions in this session. You can do that via Mentimeter. If you go to www.menti.com and enter the code 86848027. I will now just pause for a few minutes to give you a chance to go onto the Menti website. And my colleagues will read out your questions shortly. All right, I'll just pause for a few minutes. One of my team has also reminded me that you can also submit questions through question and answers function of the Teams. You will see a little icon there with Q&A. So while chat is muted, you can still use this function. Any comments, feedback, also welcome through this function. These functions rather. And again, a reminder, you can contact us. There is a email, pardon me. There is a contact email on the DSS Engage website if you think of something else or prefer to do that later. All right, just conscious of the time, go to my team and ask them to read out any questions.
Thanks, Vera. We're getting quite a few in, so if we do miss any today, please do feel free to contact us via our email address, which we will include at the end of the presentation. But to start with, the first question we have, Vera, is, are amendments to this legislation envisaged after the recommendations of the Disability Royal Commission and the NDIS review are finalised, given the likely relevance of advocacy, information capacity building, supports, etc.?
Sure, yes, thanks for that. This is something we we had been thinking about quite a lot when we were considering the timing for this bill. So really, as I outlined a few times during my presentation, it is the intention of this bill to provide broad and flexible legislative authority for a range of services for people with disability. However, of course, if it turns out that amendments need to be made, amendments can be made. But certainly this bill places us in a position to respond in a more efficient and flexible manner to the recommendations of current reviews and the Commission. Hope that answers.
Thanks, Vera. The next question for today is, I note it was stated that the Secretary is to determine whether a certificate of compliance is required in order for a provider to deliver a service. Is that a blanket rule? Can you discuss further?
So, under the current Act, we also have provisions for certain types of services requiring certifications and others not. And currently it links with the level of risk for service for people accessing those services. We're just going to make sure that this bill provides for clearer approach to certification and ensures that every existing and new type of service is actually assessed and the determination is made whether the certification is required or not. There will be, while we outline the kind of high-level principles about what it could contain, how it's going to work in the current bill and memorandum in the existing documents, we are going to have instruments to this bill which will provide further detail, and we are going to finalize those, taking into account feedback we receive from you as well.
Thanks, Vera.
Thanks.
This flows sort of from the last question, but if we could provide any sort of high-level guidance on the considerations that the Secretary may sort of have in mind when deciding whether a certificates of compliance will be required. If we could just give a broad overview.
So I think as I said, the details of this are yet to be worked out, but I'm just trying to think about example here. For example, currently, advocacy service providers and disability employment service providers are required to be certified. So these are providers who are in a regular close contact with service participants or program participants, and if you compare that with, for example, postal concessions for the blind, which is a service that provides free services for people with vision impairment when posting items which are helping them access materials to, like print materials, you will see that kind of risk is low, and that service type does not currently require certification. Now, as I said, this is going to be worked out in more detail, and I'm just wondering whether it would be helpful to refer to our legal colleagues, if that's okay. If there is something else to add.
Just on that. Sorry, my microphone was down. So this is Sarah from DSS Legal. I think just adding to what Vera had said, a lot of that will depend on the kind of risk level of each of the, whatever the service is that's being provided, the level of one-on-one contact, kind of things like that. But like Vera said, it will take into account what things brought up in the consultation. But those are the kind of broad, high-level things that'll be considered.
Right, thank you, Sarah.
Thanks, team. I might move on to the next question. The next question is about secrecy provisions. Will these align with the new Act and provide the same protections for program participants, which might be an answer for our legal team?
Thanks, Caitlin. So the secrecy provisions, they are going to be framed differently. Just the provisions in the current Act are, I guess, very old-fashioned and don't really take account of how we use and deal with information now. So they are drafted a bit differently. They will provide the same level of protection to individuals, people with disability. The issue is around kind of other kinds of information, making it easier to access information about issues there have been in the scheme, kind of higher level, in schemes in relevant programs, higher level matters that to do with at a kind of higher program level. But as far as the protection of the information for individuals, people with disability, that is going to be on a similar level.
Thanks, Sarah. The next question is, should we be adding the new Act to all of our reference material for our policies?
I would say yes. I mean, of course, the bill, it is a kind of the bill stage of hopefully a new Act at this point in time, and it is a matter for the government as to when it's going to be tabled and considered and passed. But this is going to be the new Act hopefully soon.
The next question is there a standard best practice for workers to renew the Code of Conduct committal?
Now, it is our plan to kind of provide some supporting material for providers leading up to the introduction of the new Act. So that will include information on the Code of Conduct. There is some existing material on the NDIS website, which is going to be useful. But we are going to provide more in that regard. Next question.
The next question is, how can the community be assured that disability due to episodic conditions, such as psychosocial disability, will continue to be eligible for supports under the bill?
So you will recall in my presentation, I covered the issue of defining the disability. This bill does not define disability. Therefore, it does not limit eligibility of any particular type of disability or target group. Having said that, all individual programs and services any individual program may define their target group depending on intended services and to best address needs. So in general terms, so we are not saying in this Act this is a disability type that is or is not eligible. So again, I hope this provides answers, but if any of these don't, please just let us know and we will try and answer. All right, next.
The next question is, does the bill apply to people who provide psychosocial disability services under Medicare? For example, psychologists, occupational therapists, and social workers.
Well, anybody providing services that receive legislative authority under this Act will be covered by the requirements of this Act. So I'm just trying to think what kind of so if there is a service, if there is a service that requires providers to be psychologists or social workers, that will be a service that they provide in addition to their Medicare service. It's a kind of separate thing. But let us, have to admit, have not thought about it in this kind of, in these terms. So let us take it on notice and get back to you on this specifically.
Thanks, Vera. I will just note for the person who submitted that question, if you're able to send us an email, our email address will be provided in the next slide. Just reiterating that question, we'll make sure that we give you an answer to that one, as we'll take that one on notice. In terms of the next question for today, does the bill only apply to Commonwealth funded services or state funded too?
The bill applies to Commonwealth funded services outside of the NDIS only. It does not apply to state funded services. I'm just wondering if Sarah again had anything to add to this.
Yeah, I was just going to say, although the bill itself is around Commonwealth funding, it will apply where the Commonwealth has given funding to states and territories for programs. So the bill does allow us to provide funding to states and territories, and in that instance it would apply.
Thank you, Sarah.
Thanks, Sarah. And
Just
I think we might
conscious.
just have one more for today, and then
Okay.
that'll have answered all of them. The final question for today, noting we're happy to receive any additional questions via email or our inquiries, is key personnel for an organisation tends to be unclear in the NDIS Act, and the wording is the same in the proposed Disability Services and Inclusion Bill. Is this likely to be clarified?
All right, I might refer this one to Sarah as well, because I'm not certain.
So at the moment, it isn't, but I think that's one of the matters that probably, you know, if we got feedback and, you know, for example, in this instance, if the feedback is that it's not clear, then that's definitely something we can take into account in making any changes between the exposure draft and the bill that we will hopefully introduce. So that's something we can definitely take on board if that's an area where there's a lack of clarity.
Yes, agreed. Thanks, Sarah. All right, we are going really We are going really well with time. Just warning, we've got 4 more minutes, and if you have any additional questions, please contact us via an email that you can see on the slide, sector.engagement@dss.gov.au. So thank you very much for joining us today. And again, feel free, and we would welcome you contacting us if you have any further feedback or further questions. Thank you all and have a good afternoon.